boldip.com.
Hey everybody, and welcome to the Bold Inventor Show. I'm your host, JD Hubener, with my co-host, Matt Kolseth.
Well, hello, everybody.
Hello, sir. And for those on the podcast, you're missing out because we're matching blue, right on, like perfect hue, bold blue.
What would you call this? I'd call this like a dude blue. I don't know. It's a guy
dude blue. Yeah, for sure.
So
looking
we're
good.
kind of matchy match. I studied abroad in Italy. I don't know if you know this, JD, but I studied abroad in Italy. And, we go out to the bars at night and stuff like that. But all the Italian men, when they went out in their packs, they all wore matching clothing. The men did.
That's pretty cool.
So, we basically are two brothers from Italy at this point.
That sounds so good. I've got some Italian in me. In fact, I did the 23andMe. I got it for Christmas. I was like, oh yeah, with all my hair, I got to be like half. Now it's like 13% Italian.
Hey, so that's 12 more than me. I'm uno percento.
Uno percento.
Italiano.
Hey, you got it in there. Well, it's pretty fascinating, actually. Pretty good stuff.
It is cool.
But we're not talking about genealogy or all that stuff today. We got 3 live folks on, which is awesome, and maybe a record.
A new world record. 3 live views.
Appreciate the triad of live audience. So this is a fun podcast. We're talking about intellectual property, patents, trademarks, anything in between. We are attorneys. Go for it.
Marriage advice. You and I are both, to this day, knock on wood, still happy.
You know what? That's a really good point. This will be 14 years.
Why don't we just spin off a third podcast?
Let's do it. Legal notice, we're attorneys, but we're not going to be offering legal advice here, just giving our best shot at answering our questions. Money back guarantee today for anyone who has invested as much as it is to join this. We will feature live questions. Anyone that wants to bring on a question, we will look at it as long as it's not, of course, lewd, lascivious in nature. It's been a long time since we had that lewd or lascivious. We're broadcasting today across our classic YouTube channel, Bold Patents, and our lovely folks in LinkedIn. Good to see you guys out there. Please share this, give us a like. And we're also on X today as well. No video transmission, but the audio will get transmitted. And of course, we're going to be rebroadcasting this on our podcast, The Bold Inventor, live on Apple, Stitcher, and Google Podcasts. So, you might be ready to launch in? Ready to do this?
Let's do it.
Let's get serious. And if you're serious, if you're listening, now or after the fact, you want to jump on, take a trip down that link. That was horrible. Click on that link. It's our weekly live link.
I'll edit that out in post.
Take a look at that right over here. Yikes. You click on that, and you're going to get a copy of the book right behind me. You'll get a PDF and get to learn all about intellectual property on our discovery called Chat with Dallas. Okay, we have a ton of questions. We're going to dig into it. Matt, I'm going to put you on the spot first because
Let's do this.
So we got Facebook, LinkedIn, or Reddit. Go ahead and roll the dice. Where do you want to go?
I'm a big Reddit guy.
Okay, we do have some stuff here. Let's look at this. Again, I try to pre-screen these, but some are easy, some are hard. This is kind of random. So this is a question straight out of Reddit. I'll put that in the comments here. Looking to start a brand, but there's a trademark pending for the version that uses the word and. Can we still use the name with an ampersand?
No. let's just assume for a minute that it's the exact same brand, and A&D versus the ampersand, and it's the same product or service, right? In that case, the answer is absolutely not, unless you have a better first use date, in which case we should talk. But so no, generally speaking, no, but there's exceptions, right? You could have a better first use date, in which case we could challenge the pending trademark application with an opposition at the Trademark Trial and Appeal Board. Or potentially it's in a different class of services or products entirely, in which case, let's go ahead and file it.
Okay.
So talk to your trusted trademark attorney for a more definitive answer.
And Matt, you are a trademark attorney.
I am. And I didn't say a definitive. I said mostly it's definitive. A more definitive.
Well, and I'll do a quick plug here. We have, for any confidential questions you've got, you can email matt.colseth@boldap.com.
That's me.
Thank you for that one. That was a bit of a softball starter. Here's one
It
that
was.
maybe
It was
a little bit more, a little particular, especially with the dollar signs showing up on this question. I'm looking to patent my business name, classic, and I'll take the first part of this, for an alcoholic beverage. Should I get an attorney involved? Are the estimates I see on Google accurate? $300 to $750? Is it really non-refundable if your application is not approved? Well, a couple things. I'll take the first little bit, and this is, this happens a lot. And this is the reason why, we try to do a lot of what we're doing here on this program, educate our inventors. So patenting is only for new inventions, right? For designs, novel, functional creations that are novel, non-obvious, and have utility. Trademarks are what you do if you want to try to secure a name, word mark, or design mark. So looks like they're trying to go for a trademark here, Matt. They got some questions about dollars. Do you want to speak to that?
Yeah. So the government application fees at the USPTO. So what you're paying Uncle Sam per class of application is going to be $250 or $350. Generally $250 if you're picking off the menu at the USPTO. So for example, like say you're creating vodka, like it's a vodka alcohol or whatever, right? You'd apply in the alcohol class 33 at the USPTO for vodka, and maybe distilled spirits or something like that. So your government fees are $250 to $350. That's out the door. Got to pay that to the government. Not refundable at all. But when you're talking about quotes you're seeing online for online attorneys who do trademark registration work, trademark prosecution work as we call it, I will tell you $300 to $750 is really low. So it might be a law firm you're working with, but I can almost guarantee you're not going to be working with an actual attorney. You're going to be working with a paralegal, and your mileage may vary, just like it is with any attorney, right, or paralegal. But that's definitely on the low end. I would say that is, most trademark attorneys are going to charge anywhere between $2,000 and $3,000. I think that's pretty standard.
And that's where we are. Right? We're $2,000 to $3,000, and I think with respect to cost, it is what it is. You usually get what you pay for. When you're going low cost, you're going to get some corners cut, and perhaps get a surprise from an examiner. Maybe you just don't get as much thoughtful opinion up front. And of course, the worst case scenario is you go down the road, launch a website, launch a product, get selling under a certain name, and you've now got to change your entire brand.
Right.
Perhaps.
Yep. And I will say too, our pricing is, I think, in line with most of the industry. Certainly if you go downtown to a big firm, up on the 40th floor, you're going to be paying at least double that.
Yep. All right. Well, excellent answer there, Mr. Colseth.
Thank you.
Here's Dr. Colseth. Here is a question for me. This is on the patent side. Okay. So we've got an example, and the question is, can someone get a patent for something that is a combination of two things? And this is a good question. So suppose I combine two objects, right? Object A, object B, they exist, and like a remote control and a plastic helmet, okay? And create a plastic helmet that has an embedded remote control. I love it. A lot of places to go, Matt. My head is all over the place.
I'm spinning. I can't even. Hopefully, this is just an example, not someone's real idea where they're going to put tens of thousands of dollars towards it. Because
I don't know. Yeah, I can imagine you got a lot, flying objects in a very busy dorm room or something, or college, Animal House.
Right. Yeah.
Children are hitting you. You want to just be able to change the.
Sounds weird. I can imagine like a hat wrapped in tinfoil with a remote.
Yeah.
Stuff.
Yeah. Okay. So can someone get a patent on that kind of thing? Was the last part of that question. And the answer is yes, you can. Yes, you can. The number one question will be, is it obvious to combine those two things? Has there been any publication or patent, anyone out there that's in the field that's done studies or done videos or shown that someone of ordinary skill in the art of inventing either remotes, helmets, or that type of technology would have access to, that says, yeah, you could combine these two, or here's some ways that you could combine a remote control. So as long as there's not evidence that there's someone that's published information about combining these before, it is possible to produce it. Now, one thing I do want to mention as I was reading this is there's a difference between getting a patent, which, in theory you could, and selling the product. So let's say, hey, best case scenario, we're able to get you a patent on that remote control helmet. Cool. But there may be, depending on what type of remote and what type of helmet you're using, there may be patents on the helmet, on that remote control, but owned by other entities that you would need to get a license from in order to sell that end product. So that's one of the other issues you can come into when you start putting multiple technologies together, is it's possible to get a patent on them, but it's a different story in terms of whether you can sell them in the free market without infringement. And that's what this little acronym here, freedom to operate, means. So are you free to sell it? Are you free to operate your business without the risk of infringement? So,
hey, JD, question for you. This is a question for the audience. In trademark law, in order to get a trademark registration, we actually have to prove to the government that we went to market with the product or service. Do you have to go to market with your product or service to get a patent?
No, you do not. Very good question. Yeah. All you've got to do, the burden is you've got to be able to provide evidence that it's new, first of its kind in the whole world. Second, that it's non-obvious. Third, if it's a utility patent, that it has some benefit or functionality benefit. So that's it. No actual evidence you've actually built it. All you got to do is provide with written words and a drawing, if necessary, to show enough evidence to the examiner that you could build it. That's what's called enablement. And you've done it. You've shared with the world how to go build your invention, even if you've never, ever built it. And that's kind of one of the reasons why they have 20 years. The patent office, the policy perhaps behind it is they say, well, it may take a while to get this built, and it may take a while to get it into the market to sell. We want to be able to reward the inventor, I should say, for bringing that to the world. So,
and I guess that makes sense, right? Because at the end of the day, we really, as citizens, we don't really care if you go to market with your invention as long as you teach us how to use it, right?
Yep.
Which is different than trademark law, because in trademark law, like, we don't want you gumming up the system with a zombie trademark application, right?
Yeah, exactly. Yeah, very good.
You know what? There were some smart attorneys and judges out there. Tell you what, they come up with all this stuff over hundreds and hundreds of years. Pretty clever.
Totally.
We stand on the shoulders of giants.
Let's do one more each. I don't see any live questions. If you do have any questions, something burning, don't be shy. Fire away. We'll take that one before we jump to our bold bite. Let's see. Let's go over to our buddies over at Facebook. Those guys are a little bit wilder, a little bit looser. Independent inventors, help has arrived. That's the group that we're in, and we pulled this question from. So here's our question. Haven't pre-screened this. All right. My company is offering an innovation grant for people with ideas they want to work on, they would keep. However, any IP that's generated. What are some ways to go around the IP from this project if I want to keep working on it on my own in the future? Would it be a good idea to still apply and see if I get some of that money? Okay. Good question. I'm not sure if it's worded perfectly, but if I understand it correctly,
I'm confused.
Grant money, right?
I'm easily confused, though.
Okay. It's all good. So I think one vehicle to raise money is through grants. And a really popular one that I know of and I love recommending is SBIR. I'm not going to try to spell out the acronym, but I believe it's a government grant for science-based research and technology. And so there's chunks of money they have to give away, right? By their legislation. If they don't give it away, they'll lose some sort of funding, right? And so if you can apply for them, and usually as part of that, the government will get a full free license to make, use, and sell even. I don't know about sell, but make and use that invention for the government's purposes because they're giving you money for it. So in a way, you're limiting your rights if you accept the money. So that's one example where there's innovation grants. There are probably private companies that offer these types of grants. It's something they want to have access or maybe even own the IP. One thing you should look for and advocate for as the inventor is to make sure you have the ability to make money somehow, some way with that intellectual property, especially if you're the inventor, you're putting in the hard work. So work with an attorney, a licensing attorney, one that deals with contracts, licensing agreements that can negotiate the most rights for you in that situation. You want to be able to, of course, use it, maybe to develop a version 2, version 3, and make it and sell it as much as you can. So hope that helps answer that question. That's the beauty of patent law. There's that bundle of rights, the ability to make, use, sell, and import, and those can be licensed exclusively, non-exclusively, all over the place. So don't give up too much. Make sure you get the advice of counsel.
That was a great answer.
Thank you. All right, you want to go? I'll give you an option: Facebook or LinkedIn for this one.
Let's go Facebook.
Okay, we're going to Facebook. That's very bold of you.
Thank you.
Let's look for something. Okay.
If you got LinkedIn pulled up, just shoot me the LinkedIn.
I got a big, huge list. There's about 20 of these. Here we go. Hi, everyone. Me again. I just did a search on my slogan, and I want to use it for my company, clothing and merchandise. And I realized it's very popular. And I realized in a very popular TV show, they say the same thing. It's 2 lines, very basic.
Probably not.
Oh, here it is. Very basic. For example, it's kind of like this. It's incredible, and it's life, and it is life. I know scripts are not trademarked, but copyrighted. Because I'm using mine for clothing and merchandise, I think we would be fine. Thoughts?
Well, if you think it's fine. Yeah, so here's the thing. I would say I would obviously want to know more about this before I give a definitive answer, but I can give like a mostly definitive answer.
Okay.
I would say no, because if this is an expression used from a TV show, the USPTO may deem it to be a commonly used expression. If it's like in the general, zeitgeist, right? If it's people are talking about it, people are using it, it's in memes. I mean, if it's in pop culture, potentially then it's a common expression, in which case the USPTO is not going to allow it to be registered. Second consideration is an expression like this may not actually function as a trademark. In order for a trademark to function as a trademark, it has to connect a product to a consumer, right? That's the whole point of a trademark, A to B through the trademark. And if
an example, how about this? Sort of like an idiom. Let's do that's the last straw.
Yeah.
Okay. If you're going to try to build a brand around that, what are some of the problems there? That's the
last. One, I mean, you'd want to do some research to see if the USPTO has deemed that expression to be a common expression and essentially off the table for registration purposes. Assuming that they allow it to be registered, then yeah, you could take a look at it in that particular apparel class. But that's a refusal that I see more and more often is like common expression, right? And the reason we see more of that is it's easier to find this stuff, on social media these days, and so it's not difficult in a country of 330 million people for the examiner to go research your slogan and find 100 other people using it, on various goods, services, and things like that. So one, it's a common expression, likely, in which case you may not be able to register it. Two, it might be so associated with that other company or that TV show that the USPTO is going to be like, this is from this, and it's associated with that. And do you own the TV show? And they might ask about that. Yeah. And then third, I mean, is it really functioning as a trademark, right? Or is it just decoration, or as the USPTO calls it, ornamentation? So that's where talking to a trademark attorney before you spend the money and print out 1,000 T-shirts is probably well worth your time.
Right. Very good.
Apparel's tricky. A lot of clients want to file in apparel, and that's cool. Happy to help, but it's more complicated than you think. There's so many applications at the USPTO in Class 25 for apparel. Proving use is not as easy as you might think. You can't just put the expression on the front of the T-shirt. It's got to be like in the upper left breast pocket area or on the label. So it's not as easy as most clients think it is to register a trademark in the apparel class.
Got it. Thank you, sir. All right, we're ready to go take our bold bite. We've got a brave group of a couple of guys out of college have a really unique.
Are they going to get lit up?
Say what?
Are they going to get lit up? Are they asking for a huge evaluation?
They did, and they got double what they asked for.
What?
Shocked.
The sharks were chomping, huh? Chomping the water.
Let's find out who bit. See if we will bite as well. So let me share a screen. I got the audio already sent over. This is our bold bite segment. So we're going to be doing a review of this Shark Tank pitch and giving our perspective from the IP side of things.
Cool.
All right, check on the audio for me. Doing good?
No audio yet.
No audio yet.
Is
There we go.
We're good?
We're good.
All right.
Created for students by students.
Sharks, my name is Matt Gronberg.
And I'm Sam Chasen. We're here today seeking $250,000 for 5% of our company, Storage Scholars.
Oh, guys.
So think back to your first year of college. It's the last week of school. You're saying goodbye to all the new friends you just met, and you're up late studying when you get the text message from mom. Hey, good luck on your last exam tomorrow, sweetie. Are you all set to move out?
The panic sets in. You don't have a car to buy boxes. You haven't reserved that storage unit. And you don't even remember how that sectional couch got into your dorm room.
Well, that is where we come in. You can simply go online and create an account. You can add your parent to overlook your order information. You can pay a $50 fully refundable deposit, and we'll handle your entire move out for you.
Students are given boxes, tape, bubble wrap, and labels on campus a week before final exams. They pack up their belongings, lock up their room, and go home.
We have a partnership with their university to unlock that room once the campus is empty, and we'll move everything into storage for the summer.
We'll even have all their belongings ready and waiting in their new room when they return to campus the following semester.
So Sam, who does all this moving?
That's the best part. All the moving is done by trained fellow students creating high-paying jobs on campus.
So Sharks, as two 18-year-olds terrified at the thought of student debt, we built Storage Scholars in college, which allowed each of us to graduate debt-free. Who's ready to join us on our mission to empower students across America to do the same?
Mm-hmm.
Wow. All right.
How many colleges you guys signed up?
We're on 23 college campuses.
Where are you currently?
So we're at a variety of colleges ranging all the way from New York down to Texas. It started at our alma mater, Wake Forest University. We kind of grew in the Carolinas and then kind of spread our footprint.
How much is the total move?
It averages out to $559 for the whole service. So that's boxes, tape, and packing supplies delivered on campus. That's the pickup, the storage for the 4 months, the delivery, and $100 of insurance complimentary on every item.
I'm assuming you're going to pay the college to get into their service.
So our strategy as a business is we want to partner with colleges to get like their full endorsement and create this total like key access, pack it, lock it, leave it experience.
Okay.
So we'll
$559, that's my revenue. Where are my costs?
So our costs are about $199, and that includes all of the boxes, tape, and packing supplies, the labor, the warehousing, everything. We're the only people that I know of doing the full key access system, which they pack it, lock it, and leave it.
Nobody else doing key access.
Not with the students and with the technology. And we have our own custom-built technology, which is what allows us to have the 4.8 star ratings that we do.
What's the custom technology?
It's a web app. It was actually built by his brother, who's a full-stack developer over the last 6 years. But essentially, it just does so much of the automating for our process to be able to do 3,300 moves across 23 campuses in 9 states at the exact same week of the year and nail it every time.
Wow.
Right? So there's
Impressive.
Tell us about your background and why did you come up with this?
So I grew up in a family of 2 high school teachers, and education was highly valued. But when I decided on Wake Forest University, $70,000 a year,
Wow.
I was looking at over $100,000 in student loans. And I always knew that when I got to
sure. Would you come up to 300 for 10? Do
No.
a $3 million valuation?
250 for 10. Don't worry about the valuation because it's still the same dilution, and that $50,000 is not going to change
You're
a
going to need
lot
more money. Why would you do that? Why wouldn't you run faster?
because it's not just about the money.
Well, that's true.
Mark, you have a deal.
Done.
There we go. They did a deal.
Let's go.
That's pretty cool, right?
It was
Good
awesome. Yeah.
story.
No,
Good
those
story.
guys seem like, yeah, very cool. Wake Forest, great school.
Yeah. I mean, I was impressed, and of course, I honed in on what they're talking about technology. Right? They kind of mentioned special, our own secure web app. I looked high and low, searched their name in the patent database. No patents filed or issued.
Okay.
But you don't have to have a patent to be successful. You can
Nope.
keep trade secrets. And that's what this is. They're likely keeping that under, proprietary contractual employment agreements and
Yep.
access through their confidentiality agreement very successfully. So, especially for software like this, where it may not have any exactly, really discernible uniqueness to it, they've made it work for themselves. And so it's been used in-house and kept as a trade secret. So I think it was really well done.
Yeah, super cool. Yeah, I mean, I'm looking at their website. My college is on there. So,
Hey,
hello.
nice.
What up, University of Richmond? Go Spiders. But yeah, so I mean, it looks like they've been very successful, and it's super cool to see that. I don't really love the name, but it is a registered trademark, which is fantastic. They just have a registration for the Wordmark Storage Scholars in the Transportation Logistics class 39.
Okay.
I would think that they should also have the logo registered at this point, given the fact that their evaluation is $3 million.
Yep.
Back then, you should definitely have your logo registered. I would like to see probably the mobile app protected as well, and maybe some sort of software as a service potentially, depending on what goes on behind the scenes in the mobile application. But, yeah, super cool. So you didn't see anything on the patent side?
I did not. No, and I think it's something that they perhaps had a discussion with an attorney. That's one thing I would have recommended. Earlier on, they got started in 2017, and we of course don't know. But you want to start and have that discussion with the patent attorney early to discuss, hey, is this something that's going to run into Section 101 issues? Certainly with software like this, there are eligibility concerns. Sure. If it's merely just human activity, hey, we're organizing, we're just moving storage boxes on a computer, that may fail in terms of Section 101 today, or be so sticky that they'll have to be so specific it may not be worth it to move forward with patent protection. I hope they had that discussion, but they would have had to do that in that first year of publication.
Right. Yeah.
And so they're obviously well past that. Who knows if they've got unique actual physical devices, that maybe house or have the box. If there's a unique design to their box, it didn't look like it. Those are angles that they could produce.
It seems like they just have a more convenient option, which is like, hey, sign up for the service. We ship you all the packaging stuff. You just, slop it together in your room, and then some guy comes the next day after you leave and puts it on a truck. It's a cool option. I mean, it's a lot cheaper than shipping it back to home. Used to be me living in Minnesota, going to school in Virginia.
Yeah, right.
I don't know any. I don't know of many leases, right? Storage leases that for a few months at a time. That's typically not how they do it.
Yeah, they try to lock into a 1-year deal or whatever it is.
Yeah.
Early termination fees. Those places are brutal. I've done those. Yeah.
Totally. But yeah, storage scholars, it kind of reminds me of like college painters. Is that a thing on the West Coast?
College pro painters, same type of thing.
Let's go find some, college kids looking for some work, right?
I love that too. I love that. And I think that makes sense. So
super cool. Nice find, JD. That's a good one. I like that one.
Yep.
And it had a happy ending.
It did. It was season 14, which is, I think, just a few months ago. So there's no follow-up yet. Sometimes those deals, they get done on TV, but they actually don't get done on paper. So hopefully they did follow through, and it looks like they're obviously still selling online. So we'll do a kind of a recap on them if something pops up later.
Yep, they've had a registration since 2019, I believe. So, but no attorney of record. So hey, boys, if you're listening, call me. We got to renew this trademark here at some point.
That's right. We're here to help.
Yeah, here to help.
All right, Matt, thank you as always for being a part of the show. And thank you to all you out there watching. If you have not done so yet, please give us a like, thumbs up, and share this with your community out there. We'll be here live next week. We have a inventor from the wild next week as a guest. So be well, have a good week. Go big, go bold.
Go big. Go bold at boldip.com.